Expert witness reports can be very powerful in asylum cases. They can influence decisions made by the Home Office in the UK or DHS or immigration courts in the United States and by other authorities. However, not every expert report is strong. In many cases, reports lose weight because of the serious but avoidable mistakes. Sometimes the report looks one-sided. Sometimes it does not follow legal rules. Sometimes it does not answer the real legal questions. When this happens, authorities may give the report little importance even if the country situation is very serious. In that video, I will explain the most common and most dangerous mistakes in expert witness reports and why they can weaken an asylum case. Let's look at these mistakes one by one. Understanding them is essential for everyone involved in asylum case. First mistake: report become advocacy. An expert report is written to assist the judge or decision maker. It's not written to argue the case themselves. In the UK, this may be the Home Office or Tribunal. In the United States, it may be DHS or USCIS or the immigration court. The expert's duty is to the court, not to the applicant and not to the legal representative. If the report sounds emotional, defensive, or one-sided, authorities may see it advocacy. When this happens, the weight of the report can be much reduced. A strong expert report is independent, natural, and professional in tone. The mistake number 2: commenting on credibility instead of plausibility. Credibility means deciding whether a person is telling the truth. This decision belongs to the judge or asylum officer. The expert not should say the applicant is honest or I believe everything in this account sounds trustful and credible. This is a mistake. The expert role is different. The expert may comment on plausibility only. Plausibility means whether the account is consistent with known country conditions. For example, if the court accepts this account, there is a responsible likelihood of risk. This keeps an expert within the correct legal boundaries. Sometimes there are inconsistency or difficult facts in the file. Sometimes the refusal letter raises strong concerns. If the expert ignores these issues, the report may appear biased. Authorities expect experts to consider all material facts, including facts that may weaken the case. It does not hide or avoid them. The mistake number 4: failing to engage with the refusal decision. Many expert reports describe general country condition but do not respond directly to the refusal decision. In the UK, Home Office may argue this is sufficient state protection. Internal relocation is possible, or situation has changed. The same as in the United States, DHS may argue the harm does not reach the legal threshold. The government can protect the applicant. The applicant can relocate safely. If the report does not respond to these arguments, it leaves important legal questions unanswered. The strong report directly analyzes the reasoning of the authorities. The fatal mistake number 5: generic or copy-paste country information. Some reports contain long, general description of the country. This is mistake. However, just and asylum officers do not need a general essay. They need focused analysis. A good report is specific region, specific group, specific risk, specific legal issues. If the content is too general, authorities may give it limited weight. The mistake number 6: weak or missing references. Every important statement in the report should be supported by evidence. This includes academic sources, NGO reports, government data, media reports, references to the applicant's documents. Without proper references, the report may appear unsupported. Incorrect references can also damage credibility. Even small error can reduce the authority of the report. The mistake number 7. Factual errors about the applicant's case. If the expert writes the wrong data, location, or detail, this can become a serious issue. Authorities may question the care and reliability of the entire report. Precision is essential. When summarizing the applicant's account, references to the interview records or witness statements should be clear and accurate. Mistake number 8. Acting outside the expert area of expertise. The expert should remain within their professional field. The expert should not give, for example, medical diagnosis, provide physiological assessment, make legal conclusions. If the expert steps outside their expertise, authority may question the value of the report. It is acceptable for an expert to state that a certain issue is outside their knowledge. The mistake number 9. Failing to demonstrate real and recent expertise. Decision makers need to understand why the expert is qualified. The report should clearly explain the expert's professional background, years of research, field work or in-country experience, publications, or recognized work, and how recent the knowledge is. Country situation change. Outdated expertise may reduce the weight given to the report. The mistake number 10. Not following procedural requirements. In both in the UK and the US, expert evidence must follow formal standards. In the UK, this includes compliance with the practice direction and inclusion of a statement of trust, confirmation of duty to the tribunal, clear identification of materials reviewed. If formal requirements are not followed, a judge may give the report limited weight. Even a strong analysis can lose weight if procedural rules are ignored. The mistake number 11. Not analyzing the core legal questions. An expert report must address key asylum issues, such as is there a real risk of serious harm? Is there sufficient state protection? Is internal relocation realistic and reasonable? Would the risk continue in the future? Does the harm relate to one of the Refugee Convention grounds? If the report describes country problems but do not apply them to the individual case, it remains incomplete. Authorities require analysis, not only background information. The mistake number 12. Emotional or political language. Strong personal opinions or emotional language can weaken a report. Judges and asylum officers expect professionalism, objective analysis. The tone should remain calm, factual, and evidence-based. If the report sounds like activism, it may lose credibility. The fatal mistake 13. Not reviewing all relevant documents. The expert should review all important documents in the case, such as interview transcripts, written statements, refusal decision, supporting evidence. The report should clearly list the documents reviewed. If the documents are not considered, the analysis may be incomplete. The next mistake is ignoring significant changes in country condition. If major events occur, new law, political violence, arrest, conflicts, the expert may need to update their opinion. Failing to address important changes can make the report outdated. Authorities rely on current and accurate information. And the last mistake in our list is forgetting the primary duty. The most important principle is independence. The expert's duty is to the court or immigration court, not to the applicant. The expert must be independent, objective, balanced, honest. When those standards are followed, the report can become powerful evidence. When they are not followed, authorities may reduce its weight or disregard it.